Hi, I'm Shan Wu with the Undercolor of Law hot take on the last filing, probably, in the Manhattan DA's conviction of Donald J. Trump. I think Alvin Bragg is going to get the last laugh here. He filed a reply running almost 80 pages to Trump's upteenth motion to dismiss the case. That's the one that's pending sentencing before Judge Juan Merchan. And it's a very good brief. It's very comprehensive. It rebuts all of Trump's arguments with an interesting twist, which we'll talk about. So Bragg makes short work of Trump's motion to immediately, that's in quotes, dismiss the case, based on his lawyer's rather creative, meritless idea of presidential immunity, making the obvious point that a president-elect is by definition not the president yet. That's why we call it president-elect. Just from a common sense standpoint, as we've discussed before, Trump's arguments are all after the fact, meaning the case was commenced, tried, and the conviction resulted all before he became the president-elect for the second time, and involved actions that almost entirely took place before he was president the first time. So all of the arguments about the presidential immunity really should not apply. There's a tiny fraction of the case that involves some things he said or did in the Oval Office when he was president the first time. But all the actions that got him convicted happened before he even took office the first time. So that by itself takes it out of the Supreme Court's immunity doctrine. But they're trying to actually extend that doctrine more. They want to say that the fact that he's currently the president-elect, that also comes under the immunity doctrine, which simply isn't in that case. They want it to get extended. So the prosecutors, Bragg's prosecutors, do agree that there is something to be said for the fact that he's about to become president, and they offer some potential accommodations to be made for Trump, given that fact. But those accommodations are really about the sentencing, and they strongly oppose the idea that the case should be dismissed altogether, which is, of course, what Trump would like to have happen. And just to touch on the motion to dismiss after there's been a conviction, Trump's lawyers are relying on what's called in the interests of justice standard. And in New York state law, there are multiple components to apply. You don't have to get all of them, but you got to look at all of these components, and really he hardly meets any of them. We'll put up a screenshot for you. But there are 3 points in particular that I think worth a lot of attention to. So the first is, I think, element C, which is very strong when it talks about how strong is the evidence. It was really overwhelming, the evidence in the case against Trump. He essentially had no defense to it. There's also F, which is the history and characteristics of the defendant. This is interesting, because his history here, it kind of goes beyond just his history in the case, right? Similar to sentencing, where the judge can take into consideration other things the defendant has done. In this category, there's a terrible list of things he's done. He was threatening witnesses, he was insulting the judge, as well as other kinds of actions outside of that case. I mean, he's been adjudicated by a court of being guilty of rape, defamation. These hardly weigh in favor of the interests of justice to get rid of the case against him. And another factor that's important here, I think, is the public confidence, how low that confidence would be if, given the kind of characteristics for a defendant like this, that the case just gets dismissed after this work, after a jury has found him guilty. Now, this is sort of the opposite, really, of an argument that Ellie Honig at CNN has made in an opinion piece. We can put that up for you. What he's arguing in his opinion piece is he claims Bragg really poisoned the well for other prosecutions. He talks about the idea that the problem was that he thinks the case is weak to begin with, and he also feels that it's the weakest of all the cases against Trump. And Ellie writes, if you have 4 arguments and you lead with the worst one, you're sabotaging your own case. He also thinks that the case should move back to its final resting place, back on the same scrap heap it came from. Now, it's often been the case that Ellie was very against that case. I don't really understand what his concern is with it. But there's something I want to focus on here, which is this idea that you don't lead with your weakest case. There's a terribly flawed assumption to that, which is that there wasn't a coordinated plan between Georgia, DOJ, and Manhattan to prosecute Trump. That's the hidden assumption that Ellie Honig's making there. It wasn't up to Bragg, what goes first. He didn't need to ask permission. Now, sometimes it's true. The state and federal prosecutors do coordinate on certain kinds of cases. That happens, the order of charges, who's going to go first. But that didn't happen here, and thank goodness it didn't happen, given the glacial pace of the federal charges. No fault of Jack Smith's. I'm one of the ones that continues to believe that Merrick Garland gave them way too late of a start. Okay? But there are people that disagree with my view of that as well. So when it comes to sentencing, Bragg's office makes a number of suggestions to the judge without weighing in on which one is their preference. So it's kind of interesting they do that. Usually you're going to make a pitch for one outcome or the other. Now, it's my view that the judge should just friggin' sentence the man and let the appeals work out for themselves. But Bragg is giving a lot of options here. The first option could be wait for the sentencing until Trump's actually finished his whole term. There's also the idea of you'd sentence him now, but you'd stay the execution of the sentence until after Trump concludes his term. A particularly intriguing one, though, that they offer is what they term the so-called Alabama rule, which is abatement by death, meaning a case was abated because the defendant dies before the conclusion of the case. Now, here's why I find this so intriguing, a few reasons, actually. So first, they raise the possibility of this on page 31 of their brief, which we'll put up for you to take a look at, and I'll review it myself for a moment. And what's interesting about it is this is not the law in New York. Let's explain what this abatement concept is. The typical circumstance would arise when there's been a jury verdict and there's been an indictment before that, and presumably the verdict is a guilty one because otherwise there's nothing to appeal, there's nothing else to go on to. But further proceedings, such as a sentencing, such as an appeal, is no longer possible because the defendant has died. And New York actually follows a rule called ab initio, which means that in those circumstances, the judgment and conviction is vacated and the indictment is simply dismissed. The policy reason for that is that the defendant's death makes any further appeal impossible. And we've all heard of some of these circumstances, sometimes in movies, sometimes in real life. One that comes to mind was a very famous case involving Enron, which you remember was an energy company that had a catastrophic, spectacular collapse with lots of scandals. And it was such a bad scandal that the accounting firm, Arthur Andersen, one of the largest at the time, also collapsed due to this scandal and criminal investigation. So just to refresh your memory, Enron involved a lot. It was an energy company, and they were doing a lot of fraudulent type of building and inflating the assets. Sound familiar? And a famous instrument that they created to help with this inflation of their worth were raptors. No, not these kinds of raptors. It's a different kind of raptors, a financial instrument. But it was named after these raptors. They would falsely inflate the worth by hundreds of millions. Ken Lay, he was the CEO of Enron, and he was convicted of crimes, as were many other executives. These crimes would have sent him, he was the son of a Baptist minister, possibly to jail for life. One of the things that had come out was he came from a background, dad was a minister, and he sort of developed a taste for the high life, apparently, and seemed willing to inflate fraudulent earnings to maintain that kind of lifestyle. So he was waiting for sentencing, and he was at a very fancy ski resort in Colorado, and he died of a heart attack. The federal judge threw out the conviction, which saved him, or rather his family, from having to forfeit around $45 million. Now, many states have been abandoning this rule that the death ceases everything. New York hasn't, but New York prosecutors put in a footnote to this pleading that they have urged that the New York state rule be changed, not just in this case, but it's very interesting to advance this very new notion, that hasn't even happened yet in New York, that they think it should also apply to this case. And what would happen with the abatement is the conviction would stand, honoring the jury's finding, but it would note that no appeal was possible. Now, Bragg's office has suggested this as one option for Merchan, and it's an intriguing one for a few reasons. So first, it could eliminate, of course, a lot of pressure on the judge with regard to having to impose a sentence. There's already been so much delay about it. And delaying the sentence itself causes a lot of problems because a lot can happen in 4 years to the judge, to prosecutors, to the defendant. It's a long time to postpone the sentencing. And then, of course, it avoids the possibility that this whole ridiculous argument that presidential immunity has to extend even to the president-elect, it avoids the possibility of that ludicrous argument reaching the United States Supreme Court. And if it goes to them, who knows what they're going to do with that. By doing this abatement, you avoid giving them the chance to create more bad law. Now, there are a lot of people who are going to be very unhappy if this happens, any kind of delay, really. I mean, what they feel is that Trump really just needs to be sentenced, and I agree. But I think he should be sentenced, and the reality is that there's been so much delay now, the judge is under so much pressure, we can't depend on the Supreme Court to do the right thing or not to intervene. This might just be the best way to preserve the conviction of Donald Trump. It can't be appealed, it can't be overturned. But he doesn't actually get sentenced at this point because really the chances of him being sentenced 50-50 and the chances of him getting the kind of punishment many think he deserves to get, that's beginning to look to be on the low end too. So that's one option, intriguing one. You abate the rest of these criminal proceedings, treating him as though he were dead. So that's it for now. Thanks again for the replies and the comments. They're really helpful. Try to incorporate some of them into future topics, and we'll talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.